claro, acquiesced tragiceum ingles, de forma cadavani, mantendo o tam dramatico e fluido par uso narrativo. Judge Thomas Hawthorne's courtroom was a place where tradition was wielded like a weapon. Hawthorne, a man whose bloodline traced back to the earliest colonial governors, saw himself as the last bastion of true, unquestionable authority. He presided with a blend of aristocratic boredom and casual cruelty, especially when the defendants represented a demographic he fundamentally considered beneath him. And so, when 16-year-old Sarah Miller stepped forward to address the court on behalf of her father, the air in the room thickened with the promise of humiliation. Sarah's father, Elias Miller, was a respected but struggling mechanic who had lost a long and complicated civil lawsuit filed by a wealthy real estate developer over a tangled zoning dispute. Unable to afford consistent high-level legal representation, he had watched his modest savings and small commercial property, the only home his family had ever known, slip away piece by piece. The final appeal hearing was little more than a formality. Sarah was not a lawyer. She was a high school junior known in her neighborhood for her relentless focus, perfect grades, and a mind that devoured textbooks, especially those involving constitutional law. She had spent the past 2 months sleeping no more than 4 hours a night, poring meticulously over every transcript, every legal precedent, every obscure footnote tied to the case. When the clerk called for the defense's final brief statement, Sarah rose. She wore her best blazer, a sharp contrast against the gray hopelessness that usually hovered over the defense table. Judge Hawthorne looked at the slight figure barely visible behind the defense desk, and a sneer tugged at his lip. "And who, pray tell, is this young lady?" Hawthorne drawled, his voice booming with condescension. "A child? We're not admitting testimony from minors today. Counselor, unless you intend to request recess for nap time." A wave of snickering laughter rippled through the prosecution's side. Sarah did not flinch. She met the judge's cold blue eyes with her own dark, steady, intelligent stare. "With all due respect, Your Honor," Sarah began, her voice clear and unwavering in the oak-paneled room. "My name is Seraphina Miller. I am the daughter of the defendant, Elias Miller, and I am here as his next friend representative, pursuant to Article 7 of the State Rules of Civil Procedure, Section 4.1. Hawthorne's sneer deepened. A next friend representative. How delightfully quaint. Perhaps you'll recite a poem? Maybe read us an inspiring passage from a children's book? Because frankly, Miss Miller, this court deals in law, not sentiment." He leaned back, arms crossed, reveling in the spectacle of his own authority. "Present your argument, child. Be brief. I have lunch reservations." The arrogance was breathtaking. Spectators shifted uncomfortably, anticipating a quick and brutal dismissal. Sarah opened a large, worn binder. She ignored his mockery. She ignored the systemic weight of the room. She saw only the law. "Your Honor," she continued, maintaining eye contact, "I will be brief because the law itself is brief. We are not appealing based on facts. We are appealing based on a singular procedural question regarding this court's interpretation of Subdivision C of the 1982 Eminent Domain Fair Compensation Statute." Hawthorne rolled his eyes dramatically, sighing loudly enough for the microphone to catch. "Oh, dear. Subdivision C, the darling of board law interns. And what fantastical interpretation has the high school debate team crafted this time, Miss Miller?" Sarah paused, letting silence swallow his sarcasm. "Your Honor, the statute clearly defines fair compensation as including the market value of the property plus all demonstrable lost future earnings accrued over no less than 3 fiscal years after judgment, specifically in cases involving small, family-owned essential service businesses." Yes, we know the text," Hawthorne interrupted, waving his hand dismissively. "But the established precedent, reaffirmed in Jenkins v. State Board of Zoning, 2008, limits lost future earnings to businesses with established quarterly stock assessments, a distinction meant to prevent frivolous claims from, say, corner shops." He punctuated the last words with a slow, deliberate gesture toward Elias Miller. The room chilled. Sarah's jaw tightened ever so slightly. "With respect, Your Honor," Sarah replied, lowering her tone into something serious and academic, "Jenkins v. State Board Zoning is not controlling precedent here. In fact, the language this court uses cite it is fundamentally flawed. The courtroom fell silent. No one had ever challenged Hawthorne's legal authority, especially not on technical grounds, and certainly not a teenager. Hawthorne blinked, irritation flickering in his eyes. Tread very carefully, Miss Miller. You are challenging a 15-year-old decision cited in every major land use case since. I'm challenging its foundation, Your Honor, Sarah pressed, because the Jenkins decision relies heavily on the definition of established quarterly stock assessment as outlined in Section 114 of the 1999 State Commercial Code. She turned a page and pointed to a highlighted passage. Section 114 of the Commercial Code was repealed in 2012 under the state legislature's Commercial Modernization Act. A murmur swept across the room. The prosecution team, confident seconds ago, suddenly scrambled through their binders. Hawthorne's face remained neutral, but a vein pulsed at his temple. That is an administrative footnote, Miss Miller. It does not invalidate the weight of Jenkins itself, which has been applied hundreds of times since 2012. It does, Your Honor, Sarah countered, confidence sharpening her tone. Because the Jenkins ruling is a derivative decision, meaning its operational definition depends entirely on the now repealed code. Under State Supreme Court Rule 19, subsection A, any derivative ruling whose definitional foundation is nullified by subsequent legislative action is subject to reversal ab initio. She glanced at her father, terrified, yet proud. Then she delivered the final blow. Jenkins is legally void, Your Honor. It is not precedent. It is a nullity. Without Jenkins, this court must rely on the plain language of the 1982 statute, which clearly grants my father, owner of a family-owned essential service business, the right to 3 years of lost future earnings. You cannot legally deny his compensation based on a voided decision. Silence swallowed the chamber. The lead prosecutor, Peterson, whispered frantically to his junior associate. Check the Commercial Modernization Act. Now! Judge Hawthorne's gavel slammed down, not in triumph, but desperate control. Order! Order! His gaze locked onto Sarah's with icy fury. He'd been blindsided, outlawyered, and humiliated by a teenage girl. Worse, a black teenage girl, the embodiment of everything he privately despised. Miss Miller, he hissed, venom dripping from each syllable. An intriguing argument, academically entertaining. But this is not a law school debate. Your theatrical performance will change nothing. Sit down. Sarah nodded once. She knew the threat was empty. She had used the law, the purest, most objective force, to remove his power. Over the next 72 hours, the state legal system scrambled to contain the disaster. The prosecution's research confirmed Sarah's analysis. The repeal of Section 114 had indeed created a long-ignored loophole, rendering Jenkins, the cornerstone of their case, legally unusable. Suddenly, this wasn't just about Elias Miller. It was about a systemic error that had potentially denied fair compensation to thousands of small business owners for over a decade. 3 days later, the courtroom reconvened. It was packed with reporters and legal scholars. Judge Hawthorne sat rigidly at the bench, exhaustion and contempt etched into his face. He didn't look at Sarah or Elias. He stared at his papers. This court has reviewed the arguments presented in Miller v. the State Zoning Authority. Hawthorne began, voice flat and defeated. Specifically, the challenge to continued validity of Jenkins versus State Board of Zoning. He cleared his throat. The defense's argument concerning the definitional dependency created by the repeal of Section 114 is legally sound. Sound. The bitter admission tasted like ash. Therefore, Jenkins is hereby deemed void of initio in derivative application under Subdivision C. The previous judgment against Elias Miller is reversed. The courtroom erupted. Elias collapsed into his chair, sobbing with relief. Reporters bolted for the doors. Hawthorne slammed his gavel one last time, an impotent gesture of control. Then his eyes finally met Sarah's. She didn't smile. She offered a slow, deliberate nod, not of triumph, but acknowledgement that the law, when wielded correctly, is blind to the color of the hand that holds it. Hawthorne stood and retreated to his chambers, stripped of the authority he once weaponized. Seraphina Miller hadn't just saved her father. She had nullified a decade of flawed precedent and forced the state to confront its own law, all because a judge dared mock a girl for opening a legal textbook. Her quiet act of defiance became a landmark legal correction, guaranteeing thousands of families the fair compensation they were always owed. She wasn't a lawyer, but that day she was the master of the